First up is Daniel Jones for a bail on here. Jones, Daniel Jones.
All right, good afternoon. Let's start our afternoon court session by calling the case of the bail hearing for Daniel Jones. It's case 26 GF 37037. Appearances, please.
Good afternoon, John Bake for the state.
Good afternoon, Your Honor. Daniel Jones appears in person with counsel, myself, Skylar Croy.
All right, good afternoon. So it looks like Mr. Jones was taken into the jail on the afternoon of the 1st on a tentative felony charge of stalking and a tentative misdemeanor charge of disorderly conduct. Probable cause was found by Commissioner Rome based on a Riverside affidavit. No complaint has been filed. Maybe we should start with the state for its update on that and any bail requests.
Yes, Judge, and after I speak, it's my understanding that a victim also wants to be heard on bail, so I just want to make you aware of that.
Sure.
I don't have many details, but I'm told there needs to be some follow-up. The notes here say to ask for initial appearance about a month out from today's date.
And did you want me to hear from the victim first before you talk
Yes,
about it?
please.
Okay. And I know that there are at least a couple of individuals logged in via Zoom. If the person who has information relevant to Mr. Jones's case could unmute their microphone, I'd be happy to hear their remarks.
Your Honor, thank you for allowing me to speak today.
Sure.
I support the state's request for no contact and for Mr. Jones to remain away from our home while this matter is being investigated. I have repeatedly tried to establish boundaries, and in my experience, those boundaries have not been respected. Because of that, I do not feel safe, and I do not trust that my boundaries will be honored without court-ordered conditions. I respectfully ask that the court grant the state's requested bail conditions. Thank you.
Sure. And just for the sake of the court record, it looks like you're logged into Zoom with the first name Katie, K-A-T-I.
Yes.
Okay,
My
thank you very
full name is Catherine Jones.
All right, I appreciate that. Thank you for your input, Attorney Bake. Maybe I should hear from the state regarding its position.
Your Honor, the state is recommending a signature bond with conditions that the defendant have no contact with Catherine J. It's spelled Kathryn, and that he be banned from the 700 block of South Perry Parkway in Oregon.
All right, thank you. Mr. Croy.
Your Honor, well, obviously we have no objection to a signature bond. I would ask that he be allowed to return at least once to the property with a law enforcement officer to gather his property and everything he needs to continue on with his life during this time, Your Honor.
Sure. And Mr. Bake, I assume that there's not an objection to that.
Yes, as long as there's proper notice. It's after any 72-hour no contact. I'm not sure if there was one in this case or if it's valid. But as long as there's notice and it's a preserve of the peace with law enforcement involved, we would have no objection.
Sure. Well, the accusations in the Riverside affidavit are, of course, serious just because of the nature of what's alleged. At the same time, we don't yet have a criminal complaint. We really don't have a charging instrument at all. And so the court's hands are fairly tied in terms of bail options. A signature bond is certainly appropriate under those circumstances. I'll order a signature bond. And that's particularly the case if the state says it's not really prepared to make a charging decision for as much as a month. I will order the signature bond. I'll have conditions of that bond be that he have no contact with Catherine J. and that he not be in the 700 block of South Perry Parkway. That does not preclude, and I think the clerk will include language in the minutes about this, that does not preclude him from going there in the presence of law enforcement through the preserve of the peace process in order to retrieve some belongings. That should certainly be permitted. The clerk advises me that there is in fact the 72-hour no contact prohibition that's in effect until at least tomorrow afternoon. So that probably isn't going to happen anytime before then. After that, contact the Oregon police and I think they'll work with the two of you to figure out how to make those arrangements. We also need to make an initial appearance, or schedule an initial appearance. Unless somebody has other ideas, I'm looking at August 3rd at 8:30, in courtroom 1A.
Excuse me, Your Honor, I'll just
Sure,
check
take
my
your time.
calendar quickly.
No problem.
And it works for the state well. Defense counsel's looking it up.
I can make August 3rd work, Your Honor.
Okay, real good. So we'll schedule it for August 3rd at 8:30. We're gonna get you this in writing to Mr. Jones. I have no idea what's gonna become of any of this at this point. No formal charge has been brought. It's vital that you keep in touch with counsel and that you comply with these conditions of bond. If you have contact with her or go to that place outside of the rules that we've set, you could be charged with a new criminal offense that carries up to 6 years in prison, even if they ultimately decide not to actually charge the current set of allegations. So just please be extra careful about that. I hope the best for everybody. Good luck to you all.
Right, so, no. Anybody by that door right there?
Thank you, Your Honor.
You're welcome.
Next up is George Stasel, appearing by Zoom. Sorry.
Okay, we'll next turn to the case of the state versus George Stasel. It's case 26 CM 1537. Appearances, please.
John Bake for the state.
And I believe Mr. Stasel appears by Zoom video. Here in the courtroom for him, Attorney Clayton Kavanaugh.
All right, real good. So, well, first thing I want to do is confirm that Mr. Stasel can hear us okay. If so, you could either answer out loud or give us a wave. There's a thumbs up. Perfect. That works.
Perfect. Then we've received a copy of the criminal complaint. We can waive its formal reading at this time. The address on the complaint, oh, there isn't an address on the complaint. We could use an update then. 1902 Londonderry Road. So London like the place and then no space.
He's at Londonderry Drive, and I think that's true.
My bad, Drive. Madison, Wisconsin, 53704.
306.
Oh, is that up? I don't have that on the complaint here.
We had him through court a couple of days ago and I was
Oh.
impressed.
Got it. Well, that address appears to be correct then.
And I should be clear, I don't actually know whether it's road or drive, but I was relying on the entry in the earlier cases. There are 2 open misdemeanor cases that are assigned to Judge White in branch 7. We better get this case assigned to the same judge. Does the state have a position regarding bail on this?
Yes, the state is requesting $500 cash bail with conditions that the defendant be banned from Essen House, ESSEN, and House HAUS, and that he have no contact with Grace R as in Romeo. Your Honor, as you just alluded to, this is the defendant's 3rd open case. At the time of this offense, he had just gotten out of jail that very same day. He's on video in Essen House stealing a phone. He's lying to officers that he bought it from someone, even though he's on video. I think given the circumstances here, some amount of cash is necessary to ensure compliance with bond conditions as well as appearance in court.
And Mr. Kavanaugh?
Yes, I'll first just say, obviously not Act 3 eligible, so we're only talking about that appearance in court. I haven't heard from the state any missed appearances. And in fact, in looking at some of his history on CCAP, I see 24 CM 319 signature bond, no missed appearances. 24 CF 333 signature bond, no missed appearances. So even with higher level felony offenses or charges, it appears that he hasn't had trouble making it to court. I'd also say, I mean, the nature of these charges are not such that they're just inherently, I guess, suggest that someone will flee. I understand that we wanted to continue complying with bond conditions and not do new crimes. Completely understand that. However, this has only the most tenuous connection to someone's appearance in court in the future. So I think a signature bond is still appropriate.
Well, the court record reflects that in the 2 pending cases, he last missed court a week ago today. On June 26th, the warrants were served. He had the bail hearing on July 1st, and as noted by the state, this is alleged to have occurred that same date. In fact, it's. I'm sorry, Mr. Staple, I didn't hear you.
I think it was a comment directed for-
I couldn't hear you. Okay, go ahead.
For the bail.
Yeah, so Mr. Stasel, I guess I was just pointing out that I'm gonna grant the state's request for $500 cash bail.
Dude. Oh.
Anything else before I go on? And the record should reflect that Mr. Stasel has now walked away. He voluntarily absented himself from participating in the hearing. The reasons I think are fairly obvious, but it's 3 pending cases. He missed court a week ago, had a bail hearing less than 48 hours ago, and is said to have been arrested on, well, he wasn't said to have been, he has been arrested on these new charges within literally just a handful of hours after the release. So I think that's appropriate. I'll adopt the non-monetary conditions requested by the state. I don't think Mr. Stasel can hear me anymore, but I do hope for the best for him going forward.
Edward David.
All right, we'll call the case of the state versus Edward McDavid. It's case 26 CM 1544. Appearances, please.
John Baker for the state.
And Mr. McDavid appears in person in custody with Attorney Clayton Kavanaugh. We've received a copy of the criminal complaint in this matter. We can waive its formal reading. The address in the complaint appears to be correct, and Mr. McDavid is eligible for public defender services.
Okay, thank you very much. I'm told that there may be a victim present on Zoom who wants to be heard regarding bail.
Your Honor, it's my understanding that the victim just wants to observe via the live stream.
Okay,
That's just the latest note I have.
yeah, that's kind of unusual since one can observe without actually logging into the Zoom, but they're certainly welcome either way. What's the state's position on bail?
The state's requesting a signature bond with the sole condition that the defendant not display any acts or threats of violence towards Melanita M as in Mike, Melonita.
Okay, and Mr. Kavanaugh?
I just need to briefly confirm.
Sure.
That condition's fine.
All right, let's do a signature bond with the condition that he engage in no acts or threats of violence towards Melanita M. The clerk advises, though, that there is a 72-hour no contact that's in effect until the very early morning hours on Sunday. So even though this order today isn't preventing contact, as long as it's not threatening or violent in nature, that 72 hours is still running, so you still couldn't have contact with that person or their residents until sometime during the day on Sunday. So just be careful about that. Good luck to you. Take care.
Thanks.
You're
Good
welcome.
luck, man.
Next up is Ronald Jewell.
We'll call the case of the state versus Ronald Jewell, case 26 CM 1543. Appearances, please.
John Baker for the state.
Mr. Jewell appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of a criminal complaint in this matter. We can waive its formal reading. The address on the complaint, we don't have any update for. Mr. Jewell is eligible for public defender services.
All right, thank you. My booking sheet says that he is being held on an ES hold. We should probably see if there's a specific judge that we have to assign this case to.
Say it's Judge McNamara.
All right, we'll do that. State of a position on bail.
Yes, Your Honor, the state is requesting $1,000 cash bail with conditions that the defendant be banned from the State Street Langdon area per the map. Your Honor, this is an actively eligible offense. As you just said, he's on ES. He was recently placed on probation with imposed and stayed time. He has quite a few recent sort of criminal convictions relating to battery. Most recently in cases 25 CF 2961 and 25 CF 2497, battery to a healthcare provider or family. He also has a bench warrant, a prior bench warrant from November of last year. I think given all these factors, cash bail is not only necessary to ensure protection of the public through that Act 3 analysis, but also that he abides by the court orders as well as appearing in any future court appearances.
Mr. Kavanaugh?
Yes, it is my understanding, based on this PO hold and talking to Mr. Dool for a moment, that he's in conversations with his probation agent about the possibility of an ATR or something of that kind. And a cash bond in this case would be prohibitive for him going to any kind of treatment or facility. I think that his probation agent is in a position to make an educated decision about his release. I think that the existence of that hold kind of obviates the need for cash to assure his appearance. It appears that either he's going to be revoked or held for quite a while on this. I think a signature bond would be appropriate and also not put an unnecessary, stopping to any kind of treatment that his PO may request.
All right, and I do stand corrected. I think he's on probation supervision, not ES. I think I may be misreading it, but I think his ES might be over at this point.
It's regular probation, it's not extended supervision.
Yeah, I think you're right, Mr. Dool. I think that's true. Oh, any response from the state?
No, Your Honor, I'd stand by my previous arguments.
All right, let me take a little bit closer look. All right, we'll start by recognizing that it is an Act 3 eligible offense. I think the state's correct about that. I'm then supposed to consider prior convictions for violent crimes, appearance risk, the need to protect the community from serious harm, and the prevention of witness intimidation, and then consideration of any affirmative defenses. Mr. Dool unfortunately does have prior convictions for violent crimes. That's certainly true. I don't think he has a tremendously bad history of missing court. In fact, I actually would suggest maybe it's the opposite, that he actually does pretty well making court. He's unfortunately had a lot of opportunities to make court appearances, but he's generally made them. He's done a decent job with that. The need to protect the community from serious harm is a valid consideration when somebody is charged with a battery about a month and a half or so after being placed on supervision for one. And then there's that other history that kind of plays a part there. I don't know that there's a huge risk of witness intimidation given the circumstances of this case, or more generally with Mr. Dool. I don't think how he operates generally. And I say that with some more familiarity with Mr. Dool and having had prior cases than I maybe do with some other folks. Affirmative defenses are not clear to me, but I think I have to recognize that when we have essentially a bar fight or a physical confrontation in a drinking establishment, there's always that possibility that's always a real thing. I also note that this is alleged to have happened at least a couple, if not more than that, number of weeks ago, which I suppose is relevant to something. We know that his agent is treating the situation seriously because that hold remains in place. And there's some talk about the potential for an ATR. I don't know what that looks like exactly. If I had to guess, I would guess probably an alcohol related treatment type ATR. Honestly, I could go either way with this, and I think it would be a reasonable answer. I think the state's position is justified. I think I could set that amount. If I'm doing it, I'm setting it to assure community protection. And I guess it's not so clear to me whether $1,000 bail would make or break the community protection aspect of this, as opposed to simply being preventative detention. And because I think if I set $1,000 bail, Mr. Dool essentially has no chance of release in that situation. he also maybe isn't getting released for the immediate future anyway because of the probation situation. I guess I see it as a situation where I might either be doing a signature bond or a substantially greater bail than that, and I'm going to err in support of the signature bond here. And I say that not to pretend that $1,000 cash bail isn't a significant request. It is, and it's for the reasons I've identified. I'm hoping that the job can get accomplished without doing that, especially knowing that we have the probation stuff in place. I'll give him a shot with a signature bond. I am going to order as conditions that he not be in the State and Langdon ban area. I'm also going to order that he not possess or consume alcohol. And I'm going to order a condition that he not be in any bar, tavern, or other licensed premises. I'm not looking to change the language from the standard form language that we have on a bond form. I'm not having a big issue if he goes into a restaurant that also serves alcohol, as long as he's not drinking. That's fine. We'll get a not guilty plea entered on his behalf. Mr. Dole, we're going to get you a new court date here in the next room. Right now, it's going to be between you and your agent as far as getting out of here. If you get out, you know what you got to do in order to stay out and be able to make this work out.
What I'm saying is that I already told them that I wanna go to treatment.
All right.
That I need treatment, and if I had, like you said, thank you for giving me the signature, because if I would have got the cash, then I would have never been able to go to treatment. And
Yeah.
then they would have sent me to, look, I would have gone to prison and really going to the joint with the amount of time that I got. I wouldn't have got any treatment in prison
Probably true.
because of only
So-
having 18 months.
Right. So, Mr. Dole, I'm not asking you to respond to this because I don't want you to say something that would get used against you later on, but you and I have both been doing this for a while.
Yeah, I know.
You've been there before, you know what it's like, you know how that works. And I think you know what you got to do in order to keep yourself not in that position. And I hope you make it work. I really do. I've always hoped that for you, just like anybody else that comes through. Good luck to you.
Thank you.
Good, take care.
Next up is Simon Cox, appearing by Zoom.
Okay, we'll next call the case of the state versus Simon Cox. It's case 26 CF 1410. May we have appearances, please?
John Bake for the state.
And Mr. Cox seems to appear by Zoom video. Here in the courtroom for him, Attorney Clayton Kavanaugh.
All right, thank you. And Mr. Cox, I just want to confirm you can hear us okay? If so, can you please either wave to us or say something?
Hello.
Okay, I heard you respond. Thank you for that. Mr. Cox does have another open case assigned to Judge White in Branch 7. We need to get this case assigned to that same judge. Before I call on the state regarding bail, I think there may be a victim present via Zoom who wanted to share some thoughts. So I'll turn it over to them.
Yes, hello, my name is Colleen Cox. I'm Simon Cox's mother. I wanted to speak to you to request some changes to bond conditions.
Sure.
So my request is that, of course, after the 72-hour no contact period, I would like for Simon to be able to contact me. Phone or text contact is fine. I would just like that as long as he is not allowed to physically come to the 400 block of Cantwell Court where my residence is located.
That's discrimination and
But-
assault by police officers.
And
Sorry, I think Mr. Cox got unmuted, but maybe we should, if he wants to add something more, I'd give him a chance after Ms. Cox is through.
okay, and I have one other thing that I would like to request, that bond conditions include a ban from contacting my employer or showing up in person at the office of my employer. And I don't know do you need me to share the name and contact information here, or can I provide that separately? Whatever.
Well, so it's up to you. If you share it here, this is live streamed. It's possible that the public would hear it, and then it would probably also go on the bond form. if you are confident that he knows where that is such that it doesn't have to be disclosed in this fashion to be enforceable, I guess it could be described in sort of the generic as just your employer.
Okay,
I don't know if that made any sense at all the way I explained that.
yes, that makes sense. Thank you.
Okay, so I would leave it to you, I guess, to make that decision.
Yeah, so he knows. Yes.
Okay, real good. And anything else that you wanted to add before I hear from the others?
No, that's it. Thank you.
Okay, thank you. And well, why don't we turn to Mr. Bake next?
Thank you, Judge. Your Honor, I am requesting $500 cash bond with conditions that the defendant have no contact with Colleen C. and that he be banned from the 400 block of Cantwell Street, Cantwell. I would also ask for the conditions that the victim just asked for, which was the ban from her employer's premises or where she works, place of employment, as well as no contact with the victim's employer or any employees related to her employment. Your Honor, this is a situation, it's an ongoing sort of situation between Mr. Cox and his mother. I think it's, from my understanding, Mr. Cox does have some serious mental health issues, but he's also extremely verbally abusive to the victim. You know, it's gotten so bad that there are even locks on her bedroom door at home. So these are very serious situations. You know, I know that Ms. Cox has just asked for no contact, or has asked for contact. But it's also my understanding that she did enforce 72-hour no contact at the time of this incident. And there was a previous case where Mr. Cox seems to target her, and we believe that she absolutely deserves protection, and that the cash bail is a mechanism for doing so. I do acknowledge that I don't believe this is an Act 3 eligible offense. But those are my requests for Your Honor at this time.
All right, thank you. And Attorney Kavanaugh, I certainly want to hear from you. If you'd like me to unmute Mr. Cox so that he has a chance to weigh in, I'm happy to do that, but I know often counsel would prefer that we don't do that so that somebody doesn't say something that might incriminate themselves.
I don't know if I have authority to stop him, but I would advise you, Mr. Cox, not to make any statements at this time, but I think, yeah.
Yeah, so Mr. Cox, if you still wanted to add something, I'm happy to hear it, but please give us like a thumbs up so I know that we should get you unmuted for that.
Okay, so I don't really know that much about this legal proceeding because I haven't been able to use a tablet or talk to a lawyer since getting to jail. And I gotta say, I have been repeatedly accosted and assaulted. I don't know if it technically fits the legal definition of assault, but I believe it does. By police officers that were trying to cause a problem responding to domestic disturbances, specifically with Domestic Abuse Wisconsin, where she works. And I think it's suspicious and incriminating as a threat that this charge, all these charges have not been thrown out, and the officers are not being charged or like reprimanded. Like literally, it's just like I'm gonna, you know, I also, you know, I gotta say, I would like to be able to afford getting out of jail. So excuse, you know, I'm, it's good that I was not speaking out of turn.
Nope, you're fine on that front. Attorney Kavanaugh, do you want to make an argument on his behalf?
Yes, briefly, thank you. So as for the monetary condition, we would request a signature bond. I don't think cash is necessary here. Like this state has mentioned, it's not Act 3 eligible. I haven't heard about any missed appearances. And in fact, as I was looking through his record earlier, I don't really see many missed appearances in the past, if any. I don't think cash is necessary to assure his appearance. And if, unfortunately, well, I'll leave it there. As for the non-monetary conditions, I think that the alleged victim here who spoke has made her wishes very clear. I think that seems appropriate, given what we know. If he does
I don't
break
know where to
the,
go in terms of being not wanting to interact with police officers that evicted me forcefully from the last two places that I lived by threatening me physically.
if he does come back to that home in violation of the bond condition, or is abusive verbally or something of that kind, she is of course still able to call police and have protection for that. I think that the physical geographic barrier is probably enough. I think that complete no contact is just unnecessary. So I would ask that her wishes for the geographic no contact be respected, the general no contact not be ordered, and that this be a signature bond.
All right. Well, Mr. Cox has pretty clearly expressed a wish to have his bond be affordable, and it was when he was charged a couple of weeks ago with disorderly conduct, resisting, and an allegation of battering a police officer. It was the ultimate in affordability. He was allowed to be released on a signature bond with some pretty basic conditions. And it's, again, not really 2 weeks later, and he is now charged with another disorderly conduct type offense, as well as a physical resisting episode. I won't belabor the point about the fact that there's a felony bail jumping charge. Very little of what's been shared here gives me a lot of confidence that he's likely to follow conditions of another signature bond. I don't know, because I'm not present for these events, who the aggressor is, but I have two separate unrelated allegations of a physical confrontation with law enforcement officers in a couple of weeks. Added to the other information, it causes me that concern. I don't see a viable alternative to setting cash bail at this point. The number requested by the state's actually fairly modest given the situation. I think it's also reflective of the fact that other than whatever's been going on recently, he doesn't seem to have much or any other prior criminal record, and that's a fair point. I'm also inferring from some of the statements he's made that if bail was set much more than that, it would perhaps make that much more difference in terms of his ability to post or be released. So I'll go along with that and not set it any higher. I'll set cash bail at $500. I think it's reasonable to defer to Ms. Cox's wishes regarding contact. She has articulated reasons. She has, it sounds as though if her place of employment is correct, as stated by her son, it sounds like she'd be pretty well equipped to evaluate what is safe, what's reasonable. And she's identified a plan that would allow for some ongoing contact with her son, but in a way that provides for safety. And I don't think I should second guess that at this point. So I'll set as conditions that he not have any in-person contact with Colleen Cox. Also that he not be at any location where she is present, including her place of employment, and that he not have any contact with her place of employment. I recognize that is a service provider, but given the statements made on the record here today, I'm concerned that's likely to yield inappropriate contact or perhaps misuse of a resource. And for that reason, I'll make that a condition of bond. I am going to order, of course, that he not be in the 400 block of Cantwell Court. To the extent that he asserts that condition is discriminatory, he's right. He's probably the only person currently banned from being in the 400 block of Cantwell Court. But that's because he's also probably the only person charged with having committed 2 felony offenses at that location within the last couple of weeks. We'll get a not guilty plea entered on his behalf to the misdemeanor charges. Why don't we put this case on for prelim in the next 20 days? I'm going to suggest that if we're doing that, we also take the other open case, 26 CF 1323, take off the status conference and instead schedule that for a prelim at the same time. I think that'll help move both cases along for the better of all, unless somebody has an objection to that.
I actually at this time would raise competency as well.
Okay, any response regarding that from the state?
No, Your Honor.
All right, and I assume if we're doing that, it would make sense to have that evaluation encompass both cases.
Yeah, I think that probably makes sense.
And Any objection to that from the state?
No.
Okay, so then I think there is reason to doubt competency, given some of the statements made here today, what's in the criminal complaints, and as well as counsel's statement here. I'll make that finding. I'll make findings of probable cause in both cases. We'll remove the scheduled court appearances, not put any on in the new case, other than schedule both cases for a competency hearing after the report has been produced. It is technically an outpatient evaluation because Mr. Cox is not at this point being ordered transported to a facility. If he remains at the jail, he would be evaluated there on an outpatient basis. If he postponed and is released, then it would be on a more conventional outpatient basis. He would be required to cooperate with that evaluation. I hope things work out for everybody here. Good luck to you, Paul.
Next up is Gabriel Duran. Duran?
Sure.
All right, we'll call the case of the state versus Gabriel Duran Jr., case 26 CF 1411. Appearances, please.
John Baker for the state.
Mr. Duran appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading. The address in the complaint, I think, could use an update. Is this a better address?
Yeah,
This is a good one versus this one?
that's what I was saying. My father.
Okay, so you want to use that one?
Yeah.
Got it. Okay, never mind. The address in the complaint we can keep using. Mr. Duran is eligible for public defender services.
All right, thank you. And does the state have a position on bail?
Yes, Your Honor. The state would request $2,500 cash bail with the condition that the defendant have no contact with Tara M as in Mike, Tara. Your Honor, this is, of course, as the court is aware, an Act 3 eligible offense. Essentially, as highlighted in the criminal complaint, it's alleged that the defendant forced the victim down to the ground, causing injury to her eye. It was actually the victim's friend who noticed this black eye, which is how this case started. She also reported that the defendant had strangled her weeks earlier. There are some injuries that were observed by the victim's mother, who specifically saw injuries on her neck. I think given the facts here, cash is absolutely necessary. I am seeing one bench warrant from June of 2024. Other than that, I don't have any other information on missed court at this time.
All right, and I'm certainly going to hear from you too, Mr. Kavanaugh, but I note that the PSA describes one prior violent conviction, though it looks like it may be a misdemeanor conviction. I don't know if we have additional information regarding that from either counsel or Mr. Rogers, our pretrial assessor. The complaint makes reference to a prior county ordinance violation, but that wouldn't have been that one. Maybe I'll ask Mr. Rogers if he has that information.
Judge, in 2013, he was convicted of misdemeanor battery.
Okay.
I believe that's the prior violent criminal conviction that's discussed in that.
And that would make sense then, given that net entry on there, unless Mr. Rogers has different information. I think we're good on
Your Honor,
that.
I did not hear the defendant's name, so I'm not certain which case was called.
It's Mr. Duran, but I think we were able to figure out the answer to the question, so I think we're good.
Okay, all right, good, thank you.
Thank you, though. Sure. Mr. Kavanaugh.
Yes, thank you. So first, I understand it's Act 3 eligible, but I think likelihood to appear in court again is still quite relevant. The state made reference to a prior missed appearance. However, in my review of the CCAP records, I could see that he's been on signature bond several times, even in felony cases in the last couple of years, and had no missed appearances. And in fact, the PSA seems to state no prior or no failures to appear within the last 2 years or older than 2 years. That's consistent with what I found. I don't think there's any failures to appear, even with similar exposure in the past. So I don't think the fear of exposure or anything of that kind is going to be a major factor here for his appearance. Now, for the need to protect the public and victim intimidation. I haven't heard any reference to prior issues with victim intimidation. And as for the need to protect the public, I understand this is a very serious allegation. However, this is not part of a larger pattern of behavior. His last violent offense was a misdemeanor battery from more than a decade ago. That's, I think, a pretty significant gap here. I understand the PSA is asking for cash bail or recommends cash bail. I still don't really think that's necessary here. Based on what we can see, I think non-monetary conditions would be sufficient in order to protect the public, specifically the alleged victim here. Any kinds of issues with public danger or victim intimidation, I just haven't seen any reference to or need for, significant addressing for. So I think the signature bond would be sufficient here. We've seen it work in the past. I haven't heard a significant pattern of bail jumpings or anything of that kind either. I would ask for that signature bond here.
So it looks to me like the 2024 bench warrant that was described was not a missed court appearance, but rather a pretrial services violation. It appears that he had been arrested on some new allegations, and the warrant process was used to assure his appearance for the subsequent bail hearing. But Mr. Bake, if you have additional information or any response to the defense arguments, you're welcome to.
I don't have any additional information on the bench warrant. I suppose I would just push back on one point. Mr. Duran doesn't have the most significant criminal history. But I would note, in the first paragraph, or not for the second paragraph on page 3, it does say that it's alleged that Mr. Duran had been abusive for years. So even though all these instances weren't reported, I do think we're looking at a pattern of domestic violence and an ongoing sort of engagement of domestic violence. This isn't anything new. And that's where I would lean in more on that Act 3 analysis for protection of the public and specifically protection of the specific victim involved here.
And this question is going to sound a little bit rhetorical, but I actually mean it as a genuine question. How does my setting $2,500 cash bail here protect that person or the community more generally, unless it's intended to essentially be prohibitive so that he would remain in custody?
No, Your Honor, I think the purpose of the cash bail as recognized by the legislature, the way I see it, is when there's a significant financial incentive on the line, it then disincentivizes people from violating the law as well as violating any bail conditions. So that would be the reason for the request and the large amount of cash.
So the underlying premise is that somebody may not want to risk forfeiture of that bail.
That's part of it, yes.
Yeah. I mean, that would
Right.
assume that there are regularly requests for bail forfeiture upon violations of bond, but I think I get the premise of the point. Anything else that you wanted to add, Mr. Kavanaugh?
I think I want to touch on that additional thing from page 3 that was mentioned before about there being years of allegations, or not even years of allegations, her saying now that this is a pattern of behavior. Frankly, I just think this is different than having a pattern of criminal convictions over years for violent crime and having someone report that something had been ongoing for several years, but apparently it's never risen to the point, at least not in the last decade, of being criminal for even a disorderly conduct. I think that's relevant here, or battery. I think that's relevant here. It's just different. Again, if there had been a pattern of those kinds of convictions, I'd see it, but I just don't think there's here. I think there's no reason to believe a non-monetary condition would be insufficient.
It's a hard case because, at least in my view, there's no real way to interpret what's in the complaint as anything but serious. There's an allegation of 2 separate violent encounters occurring a couple of weeks apart. That is on its face serious. It's concerning. They are Act 3 eligible offenses, which means the state's not at all wrong to argue that that community safety and the violent nature of it is something that should be in the mix somewhere in terms of the bail. I also tend to agree with the defense that I don't really have a history of missing court. I don't have a conviction from within the last decade or so of criminal convictions of of any sort, I don't think, much less for violent offenses. I have some concern about the fact that there was that pretrial services violation said to have occurred, I guess a couple of years ago now, but in connection with cases that did not result in criminal convictions ultimately. Despite there having been apparently bail violations, maybe multiple bail violations, there wasn't action taken on that, which kind of undercuts the whole argument about cash bail being effective here. I think it's a close call. And I think there's, again, nothing unreasonable about the state's request. At the same time, I don't know that it dramatically affects the safety aspect of this to set a cash bail in this case, unless it was being set at some amount that just meant he was sitting in jail. And I don't know that that's appropriate given the nature of these charges and the PSA risk profile. I think if those cases from a couple of years ago had resulted in a battery conviction, 1 or 2 battery convictions, I'd view this case a lot differently. It's just not where we are. So I'm going to set a signature bond. I'll order that he not have contact with Tara M. If pretrial services were a viable option at this point, I'd be strongly considering that, including GPS monitoring and other things. I don't think that is a viable option at the present time. So I can't use that resource. I wish that weren't the case. We'll get a not guilty plea entered on his behalf to the misdemeanor charges. He's entitled to a prelim within the next 20 days. Do you want to have that on right away?
Let me have a brief conversation.
Sure.
You can waive the time limits.
Sounds great. And Mr. Duran, you're going to be able to be released today. A big mistake would be going and having contact with her after being released, because I think that would put the state in a position to have a pretty credible argument for likely a more substantial bail than what they've asked for here today. And I don't want to see you or her placed in that position. Good luck to you.
Thank you, Your Honor.
You're welcome.
Appreciate it. Next up is Demetrius Shepard, appearing by Zoom.
Okay, why don't we call the case of the state versus Demetrius Shepard? It's case 26 CM 1536. Appearances, please.
John Bake for the state.
Mr. Shepard seems to appear by Zoom video. Here in the courtroom for him, Attorney Clayton Kavanaugh.
All right, and Mr. Shepard, can you hear us okay? There's a thumbs up. Thank you very much. And well, let's see. If I'm reading the booking sheet correctly, it looks like Mr. Shepard may be in custody on a number of body-only warrants. It looks like in 5 open cases that are assigned to Judge McNamara, which means that Judge McNamara will have to address bail in those. But we should address bail on this newest case. We'll get that case also assigned to Judge McNamara. Does the state have a position regarding bail on that?
Yes, Your Honor. The state's position is $500 cash bail with non-monetary conditions that the defendant be banned from all Target stores and that he not consume or possess any alcohol. Of course, as you just alluded, this is his 6th pending case. He previously posted cash and does not appear. He had an open body-only warrant at the time of this arrest and certainly until now. I think given all these circumstances, $500 is the minimum amount of cash necessary to ensure his appearance in court, but also abide by any bond conditions.
All right, thank you. And Mr. Kavanaugh?
Yes, there's some indication from the public defender form here indicating that the reason he had previously missed court, because obviously that's relevant here, was some form of mistake about the date, perhaps. In this situation, this appears obviously related to some form of alcohol addiction. Frankly, I understand the need for cash bond in this case. If he's previously posted and failed to appear, I just don't have a reasonable argument. I do think that a reduced amount of cash, given the fact that he's eligible for public defender services, would be sufficient, in addition to the fact that he will almost certainly be facing more from his return on his other cases. So that would be my argument.
All right. Well, I think Judge McNamara will make the decisions he's going to make on bail on those other cases. I have an obligation to evaluate it here in light of the known facts, and those facts aren't great for Mr. Shepard in terms of the number of pending cases. Even with a viable explanation, I'm not sure I hear that one yet, but even with a viable explanation for the missed court appearance on case number 6, I think the state's request is probably reasonable anyway. I'll adopt that. I'll set $500 cash bail. I'll order that he not be at any target. Also the no alcohol condition I think would make sense. But let me see if that's been ordered previously. 1 second here.
Mike's on. Can you hear
No,
me?
I don't.
Excuse me.
I can. Yep, I can hear you, Mr. Shepard.
Can I say something?
You can, but here's the trouble. I've kind of made the decision already, and if you say something, the court reporter will take it down. I'd hate to see it get used against you later on, but it's up to you.
I was actually threatened to do the things that I did.
Okay. Well, that's going to be a good thing for you to talk with your lawyer about, because that may provide some potential defenses. But for today, I don't think I can do. I'm sorry, I spoke over you. Say the last part again.
I wasn't doing it under my own passions, and I can't actually afford any cash bail or anything else, like basically extra, because I'm on a fixed income, and like most of my money goes to like the hotels and stuff, because it costs over more than the amount that I actually get in the hotel to stay there for the month and to be able to feed and house myself. And I have just a little bit left at the end of the month sometimes, but I don't actually want to be stealing stuff and stuff like that. I need to be put into a group home, and I need to be actually reevaluated into mental institutions.
Well, there's the possibility of that. Another good thing to talk with your lawyer about. In the meantime, I am going to set the cash bail with the conditions that you not be at target and that you not possess or consume alcohol. The reality is you're going to have to wait a few days at least before Judge McNamara hears bail on the warrant returns. There's probably time for you and your lawyer to ask that bail, in this case, be reviewed at the same time. That's certainly up to Judge McNamara. I hope things get better for you.
So will I be able to bond out or something like that? Because I don't know. I don't know when to actually call it. I don't have no one to turn to on the streets, and I have a counselor that I'm supposed to be able to turn to with the government, which I haven't been able to get in contact with. So I can take the right medications that I'm supposed to be taking. I'm not under the right medications that I'm supposed to be taking.
Okay, so even if I released you on a signature bond on this new case, which I just am not going to do, but even if I did that, you would not be able to be released today anyway because of those other warrants. That unfortunately you're going to have to wait and see Judge McNamara on those.
But still, that would be a good thing to get a signature bond so I can get my medication, my right medications I'm supposed to be taking.
Well, it wouldn't change your medication for the next few days, and I just can't do it. But good luck to you, Mr. Shepard.
Good thing to do to actually get me in towards of taking the good medications that I'm supposed to be taking. What you're doing wouldn't give me the medications that I'm supposed to be taking, but getting into the right mental institution will actually help me get towards the good medications I'm supposed to be taking.
I'm sure you and your lawyer can have a conversation about inpatient treatment. That's always a potential option, but we're done for today. Take care. Next up is Darnell Howard. Howard? All right, we'll call the case of the state versus Darnell Howard Jr. 26 CF 1408. Appearances, please.
John Bake for the state.
And Mr. Howard appears in person in custody with Attorney Clayton Kavanaugh. We received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. I don't have an address to update the court with, except potentially for mail, the job center at 8.
We can certainly use the job center. The booking sheet has an address on 18th Avenue in Kenosha, if that one's a better one. Either way is fine with me. Which one would you like to use?
For your mailing address, would you want to use the Kenosha one, or do you want to use the job center?
Johnson to Aber.
Okay, we'll use 1819 Aberg Avenue then as the address. That's fine.
It is also my understanding that Mr. Howard does not want SPD representation moving forward, only for today.
Okay, and that's certainly your choice, Mr. Howard. You could always hire a lawyer on your own. You could represent yourself. Or if you change your mind, always free to check in again, with public defender. That's fine. Mr. Bake, any position on bail?
Yes, Your Honor. The state's recommending a signature bond with the sole condition that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription.
And Mr. Kavanaugh?
That feels appropriate.
I'll order a signature bond. I'm going to decline to set that condition because it just duplicates the law anyway. Should we put on a prelim in the next 20 days?
Let me just briefly talk to Mr. Howard. We can wait the time limits.
All right, I think that makes sense given the circumstances. We're going to get you some paperwork in the next room, including another court date. Good luck to you. You're welcome.
Next up is Angelo Bologna Turner.
All right, we'll call the case of the state versus Angelo Bologna Turner, case 26 CF 874. Appearances, please.
John Bake for the state.
And Mr. Polona Turner appears in person in custody with Attorney Clayton Kavanaugh. I believe this is set for a bail bond hearing. I will just note that Mr. Polona Turner is eligible for public defender services.
Great, and yes, it is, we are here in return of a warrant. It looks like there was a missed status conference on Monday in front of Judge White.
And I turned myself in as soon as I could. I've been living on my car. I got my house keys, my backpack, and my phone all stolen from me on like Saturday. And I honestly missed court by about 30-40 minutes. I had no way to call. I got to my house Wednesday when I was able to use the phone. And I called and didn't get an answer right away, but then yesterday in the morning, I called again and had them come pick me up right away to scotch my warrant.
Did you call out to the house, or how did that work?
No, I called to just the Dane County Sheriff's Office.
Yeah.
To come pick me up because I knew I had a warrant and I missed my court date or whatever.
Okay, and I mean, where did they meet you to pick you up?
They came to pick me up from my house.
Okay,
Yeah,
all right,
my parents' house.
got it. Okay, thank you. I appreciate that info, and maybe we'll see if the state has a position on bail.
Judge, given that representation, well, let me just check his failure to appear history here real quick.
And I usually always make my court dates and stuff like that, and turn myself in time, so.
Judge, I don't see any recent failures to appear other than the one a couple days ago. I think given that he called the sheriff's office to address his warrant, I would recommend a signature bond, reinstating that signature bond with the same non-monetary conditions.
And Mr. Kavanaugh?
Seems right to me.
I'll accept the stipulation of the parties. We'll reinstate the signature bond with conditions that he I don't normally order this condition, but it's an existing one, so I'll reinstate the condition that he not use or possess controlled substances or drug paraphernalia without a valid prescription, that he not operate a motor vehicle without a properly functioning IID, and that he not operate a motor vehicle without a valid license. And we'll send the case back to Judge White for further scheduling. I think that does it for today. Yep, and Mr. Polona Turner calling the police, getting it dealt with was totally the right thing to do. I guess I don't know for sure, but I'm thinking without that information, this probably would have been a cash bail situation, and maybe a substantial one, so you did the right thing there. Good luck to you.
Yeah, thank you.
You're welcome.
Next up is Rakeem Willis Pettis for bail bond hearing.
All right, we'll call the cases of the state versus Rakeem Willis Pettis, or Petties. Cases 24 CM 2952 and 25 CF 2026. Appearances, please.
John Bake for the state.
And Mr. Willis Pettis appears in person in custody with Attorney Clayton Kavanaugh.
All right, good afternoon to all. We're here in return of bench warrants issued by Judge White after missed appearances on June 23rd. They're body-only warrants, but it's my understanding that the judge's office asked us to hear this because I think they're either in trial or the judge is out of town or some reason why they wouldn't have been able to get it on as timely. So we're dealing with it here today. In each case, the missed appearance was an adjudication and sentencing after prior guilty pleas. State of a position regarding bail on this, or did you want to maybe hear more of an explanation from the defense first?
Yes, Commissioner, I'd appreciate that. Thank you.
Sure, that's fine.
Yes, so I would point out as I'm looking at the record in at least one of these cases. So this is based on, we're at the stage of DPA where the state's looking to revoke and set an adjudication sentencing. It looks like the notice of the hearing went out June 16th. And then, but the hearing was set for June 23rd only. That's a pretty quick turnaround. And he didn't get notice of the hearing as it came around. And this is not like one of those kind of standard things where you should be looking and expecting that this to happen. This is one of those things where over the course of quite a long period of time, depending on how long the DPA went, you're not really expecting necessarily to come back to court for something like this. So I think that it's kind of an understandable situation, a really quick turnaround. He says he didn't get that mail notice. I would request that we don't set cash for him here. I think we can see and let it ride if he comes to court.
Do you know which address we should be using? It looks like his newer case has an address on Raymond Road. We have Verona Avenue. This one.
Raymond Road.
Yeah.
Here's the Raymond Road is right.
So the 6219 Raymond Road. Is there an apartment number?
No.
Thank you.
And I'm happy to use whatever mailing address he thinks is the best one. I would just note that the warrant appears to have been served at the Verona Avenue address. But it also looks like there may be an additional felony case, which seems to be the thing that resulted in the removal from pretrial services. Or from, not pretrial services, but the deferred prosecution. Well, does the state have a position on this?
Sorry, just one moment. I'm just looking at his deferred prosecution log here.
Oh, this gets even more interesting because it appears that he actually appeared in court on July 1st. Oh, he was already in custody. Okay. Yeah. I was gonna make the observation that he appeared in court after when these warrants were issued, but I think he was maybe already in custody on the warrants by then, according to the clerk, and that appears correct. But sorry, Mr. Bake, I didn't mean to sidetrack you.
Oh, no, and actually I appreciated the time because it gave me some time to look at his deferred prosecution notes. I don't have any information of whether or not Mr. Willis got his notice. I think he would be the only person to know that, frankly. He was aware of his new charges, certainly, because deferred prosecution made him aware of them. I think we're in a position where, someone has 3 felony cases and one of them was for a deferred prosecution adjudicated sentencing. And so I think that some amount of cash is apparently necessary for missing that type of hearing. But Your Honor, I'd leave it up to the court's discretion ultimately. I just think with the amount of exposure that the defendant now has, that some amount of cash is necessary.
I think there's a lot that went on in the course of just a few days here, and I can see where there'd be some grounds for confusion. So if I'm understanding it correctly, in the 2 older cases, the ones that are in front of us here today, he was a deferred prosecution participant. The matter was referred back to Judge White's office because he had been charged in 26 CF 1239. In that case, he posted a cash bail on June 11th, had a court date scheduled for June 25th. On that same date, that court date was removed because his attorney asked for a prelim to be set. On the 16th, Judge White's office sent the notice for the adjudication and sentencing on I think it was the 26th. On the 23rd. this would be pretty confusing with a lot of court dates within just a couple of days of each other. I agree with the defense position that a notice printed on the 16th is probably would get to somebody by the 23rd, but it's not a certainty with the way the mail sometimes works, and we're talking about an intervening weekend. And he does have the $500 already posted in the newest case, which is some assurance of appearance in court. These are also cases for which deferred prosecution agreements and changes to signature bonds were deemed appropriate initially. I think this is probably a reasonable signature bond situation. If these were new charges occurring after the cash bail release on 26 CF 1239, this would be a whole different situation, but I don't know that additional cash bail is necessary at this point. So I'll reinstate the signature bonds in these cases. We'll have the condition in 2026 that he not be at the Madison Estates Apartments on Moraine View Drive remain in effect. In 20, there's also a condition there about not using or possessing controlled substances or drug paraphernalia. I suppose we'll continue that. And then in 24 CF 2952, there's a condition to not possess any type of dangerous weapon, and we'll continue that too. So these cases are going to get sent back to Judge White's office for further scheduling. I'm thinking Mr. Willis is going to be getting notice for another court date very soon from that office on the newer of the two cases. Hopefully, future court dates will all be at the same time, so you can get this all worked out in one shot. Yeah.
No, it's okay.
Yeah,
You didn't let me know anything at all. I never knew nothing about him.
I agree the timing's tight, but you and your lawyer should be really keeping track of this at this point, because with 3 pending felony cases, it's not going to be a hard sell to get cash bail if there's an oops of some sort. Let's not have that. Yeah. You're welcome. Take care.
Good luck, man.
Please stand by that. Next up is Doris Howe for forfeiture appearing by Zoom.
All right, we'll next call the case of Dane County versus Doris Howe, case 26 CF 1207. Appearances, please.
John Bake for the county.
And looks like Ms. Haug is appearing via Zoom. Ms. Haug, can you hear me all right?
Can you hear them talk? Yeah?
Okay, so Ms. Haug, I'll try to explain this as loud as I can in the hopes that you'll be able to hear it. Ms. Haug, the DA did not charge you with a criminal offense. They charged you with an ordinance violation, like a ticket for disorderly conduct. You can enter a not guilty plea. If you do, we'll release you without you having to post a bail, and it'll just keep all your options available. You'd have another court date later. If you think you want to resolve the case today, they probably have an offer for some sort of fine to do that. Do you want to hear that offer, or did you prefer to just enter the not guilty plea?
Yeah, for the not guilty.
Okay, real good. We'll get the not guilty plea entered for you. We're going to get you another court date. I don't know if they gave you a 72-hour no contact prohibition. Oh, the clerk says that they did not. So you'll just be able to be released. There won't be any specific rules or conditions on anything, and we'll get you another court date. I wish you well.
So I get a signature bond?
Well, it's actually a little better than that. There isn't a bond at all. You'll just be released because you did not get charged with a crime.
All right.
Yep, good luck.
Next up is Timothy Schultz for forfeiture. Schultz.
All right, we'll call the case of the county versus Timothy Schultz, case 26 FO 1199. Appearances, please.
John Bake for the county. Defendant appears in person in custody without counsel.
Right, so Mr. Schultz, good afternoon. It looks like the DA's office decided not to charge you with a number of criminal offenses that you were booked into the jail on. They did charge you with 2 county ordinance violations, one for obstructing or resisting an officer and the other for possession of drug paraphernalia. You could enter a not guilty plea to that charge. If you do that, I would have to release you without bail. You'd have additional court dates. I suppose we'd do our best to try to assign those at the same time as your court dates in your various other pending. Oh, actually, we couldn't assign them at the same time as your pending cases because they're in Lincoln and Langley
Yes.
counties. But in any event, you'd be able to be released without having to post a bail. And you just have another court date here in Dane County. It looks like your ES agent has lifted the hold. too.
Yes.
Did you want to enter a not guilty plea?
Yes, Your Honor.
Okay, we'll get a not guilty plea entered on your behalf to this. We're gonna get you another court date. Is this address in Grand Marsh the best one to use?
Yes, yeah, I'm gonna be transferring all my stuff to that address, yes.
Sure. Well, we'll get you that other court date. Given what I'm reading here, it's also pretty likely that the police gave you some traffic citations.
I've been here almost 14 days and this is the first paperwork I've received.
Well, when you get your property, my guess is you're gonna have some traffic citations in
Okay.
there. If so, the reason I'm bringing it up is just to let you know that if so, this court date did not take care of that.
Okay, there's still.
Whatever.
Whatever the ticket says the date.
Exactly.
Okay.
Yeah, you got it.
All right.
Okay. Yep, good luck to you, Mr. Schultz.
Thank you, Your Honor.
Bye-bye.
Next up is Timoni Woods for forfeiture.
All right, we'll call the case of the County versus Kamani Woods, case 26 FO 1209. Appearances, please.
John Bake for the county. Defendant appears in person in custody without counsel.
All right, so Mr. Woods, it looks like the DA decided not to charge you with a criminal offense for what they're saying happened, I think over the weekend or recently, Tuesday. They have charged you with a county ordinance violation, so it's like a ticket for disorderly. You could enter a not guilty plea to that ticket. If you do, you would not be held in jail on it. You would still have other court dates and you'd still have all your rights, including the right to a trial. I'm not trying to mislead you. I think you're serving a sentence and maybe you have a probation hold, so you'd still have to deal with those issues. Did you want to enter that not guilty plea, or did you want to see whether they have some sort of like an offer for a fine to resolve this new thing?
Yeah, I want to see like a different offer or something like that. I really don't know like the difference between it and stuff.
Well, let's see what they're offering and we'll talk through it.
Offers for court costs.
Okay, so if you took their offer, you'd be found guilty of this non-criminal violation for disorderly conduct. You'd owe $214.50. That would be the fine. That's one option. You don't have to do that. You can enter a not guilty plea if you want, then no big decisions have to get made here today. And again, we wouldn't keep you in jail on this new charge. Whatever else you got going on, that's still gonna be an issue you'll have to deal with, of course.
I'll be not guilty to it.
Okay, that sounds fine. We'll get the not guilty plea entered and we'll get you another court date. I wish you well. Take care.
Next up is Cliff Woods, appearing by Zoom.
On West.
I think so. That's how I took it. All right, we'll call the case of the state versus Clifton West. It's case 26 CF 1414. Appearances, please.
John Bake for the state.
And Mr. West appears by Zoom video here in the courtroom for him, Attorney Clayton Kavanaugh.
All right, real good. And Mr. West, can you hear us okay?
Yes.
Okay, great. Thank you for letting us know. It looks like Mr. West has, well, at least 3 open misdemeanor cases. They're assigned to Judge Peacock. So we'll get this case assigned to that same judge. State have a position regarding bail?
Yes, Your Honor. The state is requesting $1,000 cash bail with conditions that the defendant be banned from the State Street Langdon area per the map, that he be banned from Capitol Square, as well as the public library here in Madison, that he have no contact with MAPD Officer Brian C. unless required by official law enforcement duties. Mr. West has open cases now. This one's a felony matter, of course, also actor eligible. He's been given 3 signature bonds, including 2 last month in June. Continues to violate terms of his bond, commits new offenses. He's fleeing from police contact in this case. I also have information that he did fail to appear, I believe, in June of
I'm able to talk right now.
this year. But a bench warrant wasn't issued, presumably because the defendant was arrested for a new crime prior to the actual warrant being issued. So the bench warrant itself would have been moot. I'm sorry. I also have information that a bench warrant was issued last year and February as well as April in 2023 and also February of 2023. So we have someone who doesn't appear in court. These are Act 3 eligible offenses. I believe that $1,000 is the minimum to accomplish all the goals that I've just mentioned here.
All right, Mr. Kevin.
Yeah, I think one thing that I want, that I think should be considered here is the ability to pay. At least from what I can tell from the criminal complaint here, I have some reason to believe that Mr. West is not going to be able to pay $1,000 of cash. I understand that there may be some desire to use that as preventative rather than actually assure his appearance. But I mean, if this is going to be a reasonable amount of cash bond, given his income, I think that that's something to keep in mind. Additionally, I think that the non-monetary conditions are a little bit too broad. I understand a non-monetary condition of the no contact with like a specific establishment where criminal activity took place. Like originally, this appears to be an Auntie Anne's originally. But moving on to like public establishments like whole streets, and the public library, that's a pretty broad situation. I understand that, at least based on the criminal complaint, it appears that that's where he went after being at Auntie Anne's. And that when confronted with police, his confrontation with police just kind of happened to be there. It's nothing really about the library or that street or anything that I think should cause us concern. The no contact with Auntie Anne's, I think that makes sense. Some criminal activity actually happened there and it was directed towards that establishment. So I would request a lower amount of cash bond and a little bit narrower of those non-monetary conditions.
All right, and any response from the state?
No, Your Honor, I stand on my previous arguments.
Okay, I think what the state's requesting is the very least that would be appropriate under the circumstances. The defendant is now on his fourth pending case. They appear to be escalating. This one alleges a battery to a police officer type charge. A credible argument could be made for a greater amount of cash bail, given that, and it's not as though the earlier pending cases don't also have some resistive or violent type aspects to them. I will order the conditions requested by the state that he not be in the State and Langdon ban area, that he not be at I think I'm going to call it the Central Madison Public Library. I can see where that's tied to what's alleged to have occurred here. Not every library in the Madison Public Library system would necessarily be entitled to the same protection under those circumstances. And it is a resource available for people for a variety of different reasons. I'll also order that he not have contact with Sergeant Brian Covington. I'm using his first name because the complaint does so, and he's a publicly known police officer. I understand the point made by the defense about the broadness of the conditions, and in fact, I'm sympathetic to that. That's why I limited the library condition as I did. I don't see the State and Langdon condition, though, as being overly broad. It's a relatively compact area of a city that has 80 square miles of land, plus a bunch of water. So it's a fairly limited area of the city. And it's also an area where behaviors of the type described in this complaint seem to be more likely to occur, and where, as an area that some would consider a gem of the city, there's probably as much need, if not more need, to have it not only be safe, but give the appearance of safety. So I think it's an appropriate condition and not overly broad. A judge might disagree with me if somebody asks for review of that condition. We'll get a not guilty plea entered on the misdemeanor charges. I assume we should put on a prelim right away?
Yes, please.
Yeah, we'll get that scheduled right away. Take care, Mr. West.
Next up is Debbie Thompson for forfeiture. Ms. Thompson. You stand up in the yellow bags.
We'll next call the case of Dane County versus Debbie Thompson. It's case 26FO1208. Appearances, please.
I'm sorry, could I get the case number again?
It's 26FO1208.
Thank you. John Bake for the county. Defendant appears in person in custody without counsel.
All right, and you're Ms. Thompson, right? Okay, so I have some pretty good news. It looks like the DA decided not to charge you with a criminal offense for what they're saying happened on Wednesday. They have charged you with a county ordinance violation. This is extremely unusual, but they've charged you with like a ticket for bail jumping. Yeah, who knew? But in any event, you're free to enter a not guilty plea to that. If you enter a not guilty plea, we'll release you without having to post any kind of bail here today. We'll just get you another court date and we'll, I think, do our best to try to get that set up for the same date and time on Tuesday is your other pending case. Is that what you want to do? Sounds good to me. Let's get that done. Just because they didn't charge a criminal offense this time doesn't mean they couldn't in the future if something new happens. So please be careful about making your court dates and following the rules in your cases. Good luck to you. You're welcome.
All right, I'll right this way. Next up is Glenda Johnson.
All right, we'll call the case of the state of Wisconsin versus Glenda Johnson, case 26 CF 1413. Appearances, please.
John Baker for the state.
And Ms. Johnson appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. I don't have an updated address for mail, but Ms. Johnson is eligible for public defender services.
All right, very good. And does the state have a position on bail?
State's requesting a signature bond with conditions that the defendant be banned from the shelter located at 2002 Zaire Road, that she have no contact with MAPD police officer Kyra H. Kyra, unless required by official law enforcement duties.
And I think the complaint identifies that person in full. Yeah, the last name appears to be Huber, I suppose, like the type of privileges. I certainly will want to hear from the defense as well, but maybe the state can give me a little bit more information about why this would be a signature bond situation.
Your Honor, I certainly understand the court's hesitation here, especially given what we had just previously ordered moments ago. I think the difference here is that the defendant here has practically no criminal history, if any. I'm trying to see if it looks like she has a pending case in Columbia County for mistreatment of animals, but no criminal history other than that, from what I can see. I think the incident here, as alleged, was she's already suspended from the shelter, but they let her in due to bad weather. She caused a disturbance. When law enforcement arrived to remove her, that's when she injured this officer. I think given the circumstances and limited criminal history, that's the reason for the difference between the cash and signature bonds here.
And when you're making that comparison, you're referring to the $1,000 cash bail in the case we just had.
Right.
Okay. And if I'm understanding it correctly, looking at CCAP, the Columbia County case is 26 CF 319, a charge of mistreatment of animals causing death. Looks like she was released on a $250 cash bail on that on June 25th. And the court authorized a warrant for her on Wednesday after she missed an appearance there.
I didn't see any warrants issued for Ms. Johnson, but our system sometimes doesn't
Well,
update.
looking at the CCAP record from July 1st, it says, and it's from Commissioner Von Hoff, VONHOFF. It says 3:29 p.m. Glenda Ruth Johnson not in court. It lists the name of an assistant DA, and then it says, based on failure to appear, state requested warrant, court authorized warrant. But then I don't actually see that a warrant was signed.
Right.
So I agree with that analysis. That court record suggests that the case had been scheduled for prelim at that time. Anything else from the state before I hear from the defense?
No, Your Honor, nothing from the state.
Okay, and Mr. Kavanaugh?
I mean, we agree that the state's recommendation is appropriate. I think that the non-monetary conditions would be enough to protect the community from serious harm. I agree that this is seems like pretty much a fluke situation with Miss Johnson. It appears that there's only really ever, she's old enough that if this was a significant pattern of behavior, I think we'd see something at this point. But we really only have these two cases, one from Columbia County, one here. I think it's reasonable to give her a shot on a signature bond out of this case, with those non-monetary conditions. So we would stipulate to that.
All right, I just want to take a little bit closer look. Well, I have some concerns here. So the Columbia County case sort of is what it is in terms of the charged offense, and the complaint. It's just sort of a mistreatment rather than an intentional kind of event. I'm not going to put a lot of weight on the nature of that specific charge, but it is a felony charge. It is between when that occurred and when the charge was lodged. She picked up a county ordinance violation here, which remains pending. Not a huge factor in the analysis, but it also does complete the picture a little bit. And that's for a case where the charge is a county ordinance disorderly conduct, but the underlying facts, according to the Riverside affidavit, involved a modest physical resisting and dead weight situation. She then posts bail in Columbia County, misses the preliminary hearing 2 minutes short of 48 hours ago, and is said in this case to have been at the shelter when, at least according to the state, she's not supposed to be there because of some sort of a prior problem. And then there's this altercation with a battery to a police officer. This is not close to a signature bond situation to my eyes. I'm going to set cash bail at $1,000. I'll order that she not be at the shelter at 2002 Zaire Road. And I'll also order that she not have contact with Officer Kyra Huber, except in that officer's professional duties. There's an aspect of her attempting to get at a taser. There's kicking. I think there's an attempt to bite the officer at some point in the course of this complaint. If it's true that she doesn't have a prior record until June of 2026, that's good in some respects, but then it's also concerning in a whole different way, and means there's a tremendous escalation here that I think has to be arrested, so to speak, with some sort of a bail response at this point. I just don't think we get from a $250 cash bail, a missed court appearance, and an allegation of a battery to a police officer and have the bail become less serious. That defies logic to me. So we'll set her up with a timely preliminary hearing. Bail can certainly get reviewed at that also. Good luck to you.
All right, Mr. Johnson, right this way. Next up is Katrina Hammonds.
All right, we'll call the case of the state versus Katrina Hammonds, case 26 CM 1535. Appearances, please.
John Baker for the state.
And Ms. Hammonds appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the complaint. We can waive its formal reading at this time. The address on the complaint. I think updated mailing address could just be the Beacon. And Ms. Hammonds is eligible for public defender services.
Sure, well, we'll get that updated. That's fine. There is an open misdemeanor case assigned to Judge Hiltman, Branch 8. We'll get this case assigned to that same judge. I think there may be a small cash bail in that matter. What's the state's position regarding bail?
The state's requesting $250 cash bail with the conditions that the defendant not consume or possess any alcohol, and that she not possess or use any dangerous weapons, as that term is defined by statute. Your Honor, it's my understanding that Ms. Hammonds has 3 open cases and was recently convicted for disorderly conduct while armed with a dangerous weapon. It's also my understanding that she posted $300 cash bail between those 2 already open cases. Despite posting cash bail, she continues to violate her conditions, obviously here by committing a new offense. I do believe she has some failure to appear history, and I'm just going to outline that now. I do see one from July of 2025 that was eventually served in August 2025. Also one from July of 2022. Those are here in Dane County.
And
Oh, no.
I'm sorry, Mr. Baker, I didn't know if you were.
No, I was just looking more at her history, but no, I'm done now. Thank you.
Sure, and I do stand corrected. It is 2 open misdemeanor cases. Yeah, but Mr. Kavanaugh, if you need a moment, that's totally fine.
Perfect, thanks.
Sure.
So it is my understanding from talking to Ms. Hammonds that the missed court appearance mentioned before was due to being in the hospital. It's also my understanding that Ms. Hammonds has a surgery scheduled for just a couple days from now on the 5th, I believe. So it's pretty important to be out and able to get there. As for the actual charges here, I mean, what we're talking about here fundamentally is a disorderly conduct and bail jumping. I understand there's that use of a dangerous weapon modifier. But if I remember my review of the complaint, yeah, I don't see anything rising to like an uncharged battery or anything of that kind. Just I think that's relevant here. The conduct is not all that heinous, again, just rising to the level of disorderly conduct and bail jumping. I understand there's a concern with the pending misdemeanors. However, I don't see a substantial history of failing to appear. The exposure is limited. And given the other factors that we've kind of mentioned already, I think a signature bond would still be appropriate, or just a much lower, or just a lower cash bond. I understand that 250 is low considering the spectrum of possible cash bonds, but when someone's eligible for public defender services, every dollar counts. That would just be more than what she'd be able to post.
All right, any response from the state?
No, Judge, thank you, or Commissioner, thank you.
No problem. I'm just gonna take a second to look at the complaint a bit closer. Well, I hate to throw a wrench into the works, but is there actually probable cause for count 1 in this complaint?
I like that wrench in the works. We can throw a wrench in the works.
I mean, I think count 2 certainly is supported by probable cause, regardless of the outcome of count 1, but I'm not sure I actually. And maybe somebody can spell it out better for me. I'm not seeing what's in the complaint that would constitute a criminal offense. Oh, you know, there's one sentence that probably does it. There's a description on page 2 in the paragraph. The first paragraph under contact with CTD that describes her stabbing a bench. I think probably that in combination with the other stuff would be at least probable cause. if either, I'm sure the state's not going to try to change my mind again on that, but Mr. Kavanaugh, if you want to make an argument on that, I'll certainly hear it.
Commissioner, I think your instincts are great. I think we should go with the original instinct. No, I understand what you're talking about when I frankly didn't raise a motion for probable cause based on that same sentence. I do think that it's an extraordinarily weak disorderly conduct based on that. I think that it is reasonable to consider probable cause at this stage for that. I mean, stabbing a bench, it's not accompanied by criminal damage to property or anything of that kind. It's just kind of wielding a knife in a weird way. I mean, I get it that we're all inferences going to the state here, but that's I don't know. I think that's a pretty weak disorderly conduct, but I think it could be a toss up.
Sure. I agree with that analysis, that it's probably not on the strong side in terms of what's alleged with respect to the count one. Count two is pretty strong, given what's alleged here. I think count two, given a third pending case, probably justifies cash bail, even separate from count one. Kind of tough for me to argue. I think with the state's requested bail amount, it's less than what she has posted in the two other cases. We probably wouldn't have the ambiguity or the question about count one if it wasn't for the alleged violation on count two. I'm going to adopt the state's recommendation here. I'll set cash bail at $250. I'll order the condition that she, you know what? I didn't write it down. I thought it was no alcohol and no weapons, but reminds me.
That's correct.
Yeah, those are, I think, appropriate conditions in these cases. I don't want to take away from the defense arguments that have been made here. I think there's truth to them, but I just, there's nothing here is particularly assaultive. I acknowledge that. But it's three cases and she's already on cash bail. I don't think we're at the point where we're gonna start doing signature bonds here. Right? Okay, right. If there was some other intervening arrest, I'm not holding that against you. We're just talking about the three cases that you want to charge. All right. Well, I wish we weren't in this spot, but unfortunately, this is where we are at this point. Good luck to you, Ms. Young. Take care.
All right. He's still already got
Please.
Yeah.
Next up is Felicia Braxton.
Right. All right, we'll call the case of the state versus, is it Felicia?
Yes.
Yeah, Felicia Braxton, case 26 CF 1412. Appearances, please.
John Bake from the state.
And Ms. Braxton appears in person in custody with Attorney Clayton Kavanaugh. We received a copy of the criminal complaint in this matter. We can waive its formal reading at this time. The address in the complaint appears to be correct, but Ms. Braxton is not eligible for public defender services.
All right, so they're saying that they think right now you make too much money for a public defender. Despite that, the bailiff is handing you a sheet that describes how to apply for a public defender. You're always free to check in with them again, or if something changes with your resources. You're also free to hire a lawyer on your own. You could represent yourself. If the public defender still says no, and you really don't think you have the dough to hire a lawyer on your own, there's a process where you can also apply at the clerk of court's office. Sometimes they can get you a lawyer with like a payment plan. You're in good hands for today. He'll help you today. State of a position on bail on this?
Yes, the state's position is a signature bond with conditions that the defendant have no contact with child victim one or the child witness one, that the defendant not engage in any physical discipline of any child, and that she be banned from the 1100 block of Moraine View Drive here in Madison.
And well, the defense position?
Yes, I understand the concern about protecting the witness and alleged victim here. I don't think it's inappropriate to have a non-monetary condition to that effect. I do think that a no contact is could cause some issues. I would request that that condition not be no contact, but rather like no unsupervised contact, or maybe even no violent or abusive contact. I think that the condition, frankly, of no physical discipline already addresses the issue here, and is broad to a degree that I think is appropriate. If we need a more targeted condition at these two children, then I think that no unsupervised or no violent or abusive would be fine. I just think that no contact could cause some serious problems considering they're minors, and this is at least one of their mother.
Any response from the state?
Yes, Your Honor, I would disagree and object here. Your Honor, the defendant, as I understand it, from what I've been provided here, my information is that she is not the primary caregiver, so contact is not even needed. This report was screened by CPS as a social worker assigned in investigating these concerns. I have notes that there was physical abuse in the past, and honestly, the allegations of this incident are extremely alarming for the child victim's relatively extremely minor conduct, in my opinion. So I think no contact is absolutely necessary in this case, and I don't think there would necessarily be anything standing in the way of that, so to speak.
I wonder if I can figure out anything more about those broader family dynamics, but certainly, Attorney Kavanaugh, if you have more to add, or if you want to take a second to consult with her about it, that's fine.
Okay. Got it. That makes sense. Okay. Okay, so my understanding of the family dynamic here is that Ms. Braxton facilitates contact between so this is, it appears the child victim here is grandchild. And so she facilitates contact between her daughter and the father of this child as well. So kind of facilitates the transport back and forth.
We're on the phone so we can speak too. The victim's here.
Oh, I was
Well, that would
not
be
aware
useful.
of that. So why don't we let Mr. Kavanaugh finish, and then we'll certainly give you a chance before decisions get.
Well, before I stumble into saying something that's not true, I'd love to.
Sure. Yeah. Why don't we go ahead? If you want to, ma'am on Zoom, if you want to
On the
unmute.
phone so we can speak too. The victim's here.
Oh, okay, can I just get that? So. Kavanaugh finish, and then we'll give you a chance.
Hearing.
Okay, and.
Okay, so I'm
Go
gonna be
ahead.
honest with you. Shalea's dad is currently incarcerated as well, and he failed to protect her. Felice has not orchestrated any court or any of the legal matters in years. In fact, I have text messages to prove that she doesn't facilitate rides with my daughter. So we do not need any contact with her. Shalea is seeking treatment behind this, and my baby's body is severely bruised still today. So we want no contact.
And just so that we're clear with the court record, can I get either your name or initials or something that we know?
Yes, I'm Braxton's mother. My name is Donya, DonyA. My last name is Waller, Waller.
Okay, I appreciate it. Thank you for sharing that, and I'm sorry we didn't call on you. I don't know that we knew you were on the line, so appreciate it. Either counsel, if you had more to add, that's fine.
Oh, no, I'm just I contacted CPS. They contacted me. They advised me to get a child abuse restraining order. So we're going for no contact at all. It's been too much abuse. I have too many, it's been too much. Enough is enough.
And Ms. Waller, can you just fill me in? And with whom is the child placed in the family court case?
Me, I have full custody and primary physical placement. Mr. Braxton has visitation Saturday, 5 p.m. to Monday when he drops her off at school.
Okay, thank you. I appreciate that. And again, I'll give both counsel an opportunity to weigh in more if you like.
I don't have anything else to add.
Your Honor, just No, I don't have much to add. I just think their position is entirely consistent with the victim who's spoken here today.
Okay, and I'm just taking a closer look, and I don't want to hide the ball. I'm actually looking at case 15 PA 833 PJ, which is the family court case to see how this all matches up and how the pieces fit together. So one moment, please. Okay, I did do my best to try to look through that family court record as best as possible, because I understand the arguments kind of being made on all sides about why there has been contact, why there might be continued contact, and the like. As best as I can see in the family court case, the placement order is consistent with what was described by Ms. Waller, that the child, or might be children, but the child is placed primarily with Ms. Waller, and Mr. Braxton is in custody, and also would only have the limited placement periods that were described. I don't see a specific order for any periods of placement with Ms. Braxton. However, there was at one point a hearing a number of years ago where Judge Samuelson granted a petition for grandparent visitation rights. I'm not locating the specific schedule, but the gist of this is that she does not appear to be sort of the majority placement resource. I think given what's alleged in the complaint and the need right now to make sure that everybody is safe, both from in the obvious way, but also I suppose from accusation as well, it's probably reasonable to grant the state's request. Nothing's forever in these things. These things can always get adjusted if appropriate. I'll order the signature bond. I think that part was not controversial. I will order the condition that she not engage in the physical discipline of any child. I will order a condition that she not have contact with, I'm going to specifically say of SLB. I'll order that she not have any unsupervised contact with MMW. I think there's a reason to distinguish between the two children, and how that works. And if Ms. Braxton is not somebody with legal sort of parenting or placement type rights with MMW, there still is an ability to control that on the part of the parent or parents. On the Moraine View issue, I'm trying to figure out how that. Oh, I see. Yeah, and absent some other argument that I haven't heard yet, that would seem to make sense under the circumstances if we're also doing the no contact condition. So I'll adopt that. Let's get in the matter scheduled, but do you want a prelim within 20 days, or should we put it on for status later?
We plan to waive the time limits.
Yeah, that's a better way of answering the question I meant to ask. Thank you. So I'll accept the waiver of time limits. Ms. Braxton, you'll be able to be released today. Time will tell how this all sorts out. I hope things go well for you, and of course for the kids too. Take care.
Thank you.
You're welcome. Bye-bye.
Bye-bye.
Bye.
Bye-bye.
Oh, Fields?
All right, we'll call the case of the state versus Willie Fields. It's case 26 CM 1534. Appearances, please.
John Bake for the state.
And Mr. Fields appears in person in custody with Attorney Clayton Kavanaugh. We've received a copy of the criminal complaint in this matter. We can waive its formal reading. The address in the complaint appears to be correct, but Mr. Fields is not eligible for public defender services.
All right, thank you. So Mr. Fields, I think they're saying that you maybe have too many assets or resources to qualify for a public defender. Despite that, the bailiff just handed you a sheet that describes how to reapply. You're always free to do that. If you think you want them to check the numbers again, or if something changes with your money.
Sure.
Yeah. You also could hire a lawyer on your own. You could represent yourself. If you don't think you do have enough money for a lawyer, there's a process for asking for one through the clerk of court's office too. He's gonna help you today. You're in good shape for today.
Okay, good. I shouldn't be, man.
Okay, well, we'll work through at least the bail aspect of this here today. What's the state's position regarding bail?
Thank you, Your Honor. The state is requesting $500 cash bail with conditions that the defendant have no contact with Shirley C. and that he not consume or possess any alcohol. This is an act eligible offense, Your Honor. It's alleged essentially that the defendant struck the victim with a broom multiple times, resulting in some bleeding and some more serious injuries. Certainly not to the level of substantial or aggravated battery, but perhaps more than what we're used to for misdemeanor battery. I will note also, it seems that the defendant has several failures to appear recently, one from January of this year, December of last year, July of 2023, and October of 2022. It also appears that he had several cases open and pending until he resolved many of them, or all of them at the time, in March of this year.
Okay, and the probable cause affidavit suggests that Shirley's first name is spelled a little unconventionally. It's on there as Shirely. Is that consistent with what you have?
I have Shirley.
All right, maybe there's a typo on the Riverside affidavit, but Mr. Kavanaugh, what's the defense position on bail?
We would ask for a signature bond. I understand the pattern of missed appearances. I saw that myself when I was looking at the CCAP records here. I just also look at the nature of these offenses. I understand that it's a battery, and I think that's, I mean, obviously Act 3 eligible. As batteries go, though, I think that looking at the use of a dangerous weapon enhancer on the disorderly conduct is a little bit, it might give a worse look than really is, as was mentioned, a broom. Now, it obviously was used in a way that's wildly inappropriate, but as batteries and disorderly conducts go, I don't think this is the worst we've seen. And as you can tell here, Mr. Fields is some issues with mobility himself, and I think that for his physical danger to others is just pretty limited. I don't think there needs to be much bond conditions designed to protect people physically from him, although I understand in this situation something happened. It appears only because it appears that the alleged victim was asleep. I think a no contact can address that pretty well.
And I would note from the other recent cases, it looks like the spelling of Shirley on the bond forms in those cases was the conventional spelling. The clerk does note that the 72-hour no contact prohibition was waived, for what that's worth. Mr. Fields, it looks like you want to add something. I'm happy to hear it, but the court reporter takes it all down. Sometimes that stuff gets used against somebody later on.
I can reach out if I want to restrain order. This is my house. I never wanted that. She painted her butt at my house because I'm handicapped and I'm a Vietnam vet. I get veterans money. I get Social Security. I get a post pension. She's there for my money. I want her out. I never would have been there if it wasn't for that.
All right.
I don't have no problem. I'm at home. I'm living alone. And she's creating a problem for me.
And well, I appreciate that information. Anything else that either lawyer wants to add?
None from the state. No.
We're just looking at those recent cases.
Yeah, all of those from her.
Let him finish.
I want her out.
They won't do that today.
Not sure.
Well, I can get a restraining order or something.
Sure, not a thing we can do today, so
Okay.
let's address this.
Well, that's true, but we can talk about the process for it, because there is
Yeah.
a process for it
I don't
potentially.
I don't wanna come here.
So
She ain't my wife, she ain't my girl.
did you say she's not either of those? Is that what you're saying?
No,
Yeah.
she is.
Okay. Well, then it's a little confusing why there are all these cases from the end of last year and earlier this year. And maybe one explanation is what Mr. Fields described earlier. Another is that crimes are being committed because he was convicted of multiple crimes out of those cases. I think 2 disorderly conduct charges ultimately out of a lot of other charged conduct. Though given those cases, or looking over the history of those cases, there appears to have been sort of an escalation of bonds until eventually he wound up sitting in jail for about 4 months. Well, the equivalent of a 4-month sentence. I think it was a little over 3 months, ultimately resolving him on a couple disorderly conducts. It's hard for me to know how much weight to put on those because they were charged as felony offenses, resolved as pretty low-level misdemeanor disorderly conducts for time served, but they still were resolved with convictions and a fairly significant amount of time spent in custody. And now I have, just a couple of months later, a new allegation of a physical encounter with strangulation. Well, that strangulation's uncharged, but it's factually alleged. And then this broomstick incident.
That's what I mean, I'm tired of it.
Yeah. Well, I don't know that there's a viable alternative to some sort of cash bail at this case under an Act 3 analysis. One could argue I'm being a little inconsistent in my statements about this versus some I made in some earlier cases where the state asked for cash and I didn't set it. I think one distinguishing feature though here is that very recent set of cases involving the same person and multiple convictions and jail sentences, and a recent demonstrated ability to post fairly substantial cash bails. I think the state's position is unfortunately warranted. I'm going to set cash bail at $500. I'll order that she not have contact with Shirley C.
Can you throw out my house?
Well, I can order that you not have contact with her.
Right.
Right.
You gotta get out my house.
Okay, and then there's a couple of options here. I'm going to indicate, first of all, we'll enter not guilty pleas on your behalf to these charges. I think that's important. Right now, you haven't been convicted of these things. That's what the rest of the process is about. The clerk is reminding me that I forgot to say, but I do intend to order the no alcohol condition as well. Mr. Fields, there's a couple of things here. I can't give you great legal advice on this, but if somebody doesn't really have specific standing at our residence, there is a process for filing an eviction action in small claims court. Might be a good thing to talk with a lawyer about. There's also a process if you've been the victim of some sort of a violent criminal offense or harassment to apply for a restraining order. Under some circumstances, those can result in somebody being removed from a residence. It wouldn't change the fact that you still can't have contact with her though.
Yeah, but I want her out of my residence. I don't want no contact with her.
All right, well, I think we're on the same page about that part of it. So that's good. Good luck to you, Mr. Fields. Take care. Bye-bye.
Next up is Jason Mountain.
Mousy?
All right, we'll call the cases of the state versus Jason Mounsey, cases 26 CM 587 and 26 CF 764. Appearances, please.
John Bate for the state.
And Mr. Mounsey appears in person in custody with Attorney Clayton Kavanaugh. We're in receipt of both criminal complaints. We can waive their formal readings at this time. The address differs on both.
4528. Mine.
45, that's a better one?
Yeah, it's
Okay, so the 4528 Gulf Drive, that's the better one. Mr. Mounsey is eligible for public defender services.
All right, thank you. And it does look like he was extradited from St. Johns County, Florida.
I was on vacation in Florida.
Okay,
I didn't know that there was court dates or warrants put out, and I've never served papers.
sure. And well, we'll talk more about that. What's the state's position regarding bail in these cases?
Your Honor, the state's recommending a signature bond in both cases. I'll start off with non-monetary conditions in 26 CF 764 that the defendant have no contact with the following people. Yidong J, Yidong, Kenneth Q, Kenneth common spelling, Kathleen L, Kathleen, and Varsha P, Varsha, that the defendant be banned from the UW Madison campus and any UW Madison buildings or property. And finally, that the defendant have no contact with any UW Madison students or staff members. For the 26 CM 587 case, requesting non-monetary conditions, that the defendant not be at or around the 700 block of University Bay Drive apartments.
All right, and Mr. Kavanaugh?
Most of these things I got no problem with. I think the non-monetary conditions are mostly fine. The monetary conditions we're totally fine with. The no contact with the UW campus or students or staff just feels like kind of a lot here. That's a huge chunk of the city of Madison. And students and staff for the university are kind of unavoidable in the city. I think that that would cause a really big issue if every time he saw a student, he had to dodge them.
How would you know?
How would you know? I mean, it's kind of a fair assumption that every person under the age of like 25 could be a student. I just think that's kind of a lot. And so I think that the students for sure, the staff also, I think you just can't really tell. And again, that's a lot of staff. And I also think campus is a little broad as well. Campus for UW-Madison encompasses kind of a sprawling area of a lot of downtown. I think the rest of them make a lot of sense. I think what we're looking at when we talk about those conditions is trying to prevent something like this from happening again. Totally fair. It's going to be a bail jumping if he does it anyway. I think that's a pretty good disincentive built in already. It's already a court order not to commit new crimes. Given that that's just kind of a hard condition to nail down and narrow down in a way that makes sense, I would just ask that the no contact with students, staff, and the campus just not be granted.
And any response from the state?
No.
Okay. Well, the first question is signature bond versus cash bail is the unusual case indeed where somebody's extradited from a distant state and there would be a signature bond. There also is something to be said for what Mr. Muncy said about notice. That is, it's not clear that he missed a known court appearance in these cases. It looks like there were attempts to serve summonses. The affidavit of non-service from the sheriff's office indicates a number of efforts to serve at the Gulf Drive address, the last of which says in Florida at a treatment facility. So perhaps it was a working vacation, but there was at least some indication that he was of where he was. And then the next step taken was to issue a warrant rather than narrow that down or attempt some other effort at service. And maybe they didn't have other leads as to where, and fair enough. But that's a long way of saying it's probably workable to do the signature bond as requested by the parties here. So I'll do that. I'm going to adopt the conditions that were requested in each case with what I understand to be the change requested by Attorney Kavanaugh. So in the case with the UW ban, I'll order that he not be in the Madison campus ban area as depicted on this map. It's a finite area. My recollection is it excludes UW Hospital as an example. It excludes most sort of service providers that would be in that area.
I do catch buses, so sometimes the buses go through those places.
And I think that map is drawn in a way where you can go down University Avenue.
Okay.
Without violating the conditions.
Okay. That's fine.
Yeah, I think that's essentially right. You know what, just to be clear about that, because I know University Avenue is a very common bus route. I will
not on foot or anywhere.
Exactly. I'll have the exception be except while on a Madison Metro bus. Yeah. And then it's an important area of the city. It's not an insignificant part of Madison, obviously.
I'll avoid as much as possible.
Exactly. But I want to be clear for the court record. I also don't think it's an improper imposition because of it being a target-rich environment and the allegations in the burglary complaint about efforts at multiple buildings and the like. It's if there's any truth to what's in the complaint, it's sort of a self-selected condition. So I'll adopt it. I'm going to not set the condition about contact with UW students or staff or however that was phrased. that could include a variety of different people that would really have no connection whatsoever to this. It presumably would keep him from, I suppose, writing a letter to the athletic director or contacting the Board of Regents or doing a variety of things that really don't address the particular concern that's raised by the complaint. Physical presence there does create that concern, and I think that's a different animal. So with those changes, I'll adopt the signature bond with the requested conditions. We'll get not guilty pleas entered for Mr. Unsi. Do you want Freeland within 20 days on the felony
I'm
case?
sorry, Commissioner, for the misdemeanor, are you adopting permission that was requested?
Yes.
And then I'll just get a little bit of clarification. I think I had heard, defendant not being in the 700 block of University Bay Apartments. Is that a row?
Sorry, I meant to say the 700 University Bay Drive apartments. I think the apartments are located at 700 Bay Drive.
Would not be in the 700 block of Bay Drive?
It's University Bay Drive.
700 University Bay Drive apartments.
Well, I think the two of you may be saying two different things. So, Mr. Bake, is the request that he not be at that building or that he not be on that block more generally?
That building, which is located on 700 University Bay Drive.
Okay. So I'll order that he not be at the University Bay Drive apartments. Is that what we decided it's called?
That's the address. The building itself is called. Oh, I guess the building has the same name as the address. Yeah. Yep, you're right, Commissioner. And also, I had requested specific no contacts with individuals in the CF case.
Yes, and I do intend to order.
Okay,
Yeah.
thank you. Sorry to
Right.
rush you.
Yeah, I'm adopting all of the state's requests with the kind of the bus exception we described, and I'm not setting the no contact generically with the UW employees and staff. The specific individuals, for sure, it's an appropriate condition. Yeah,
We intend to waive time limits.
great. Thank you for reminding me where we were, Mr. Kavanaugh. Mr. Runcie, good luck to you. Hopefully you'll make your court appearances, you'll work through this. Obviously, if there are new problems or you miss court, they're gonna probably remind us of the fact that you had to be extradited from Florida, and it might change the analysis. Let's not have that happen.
Thank you, sir.
Good luck to you. Take care.
Good luck, man.
Next up is Devin Wilson. Sorry, man, I said, why that was that?
Oh, it's confusing. They're so similar sounding.
Oh, Mr. Wilson.
Weird name. Yeah, I didn't think it had the same list. But
All right, we'll call the case of the state versus Devin Wilson, case 26 CM 1538. Appearances, please.
John Bake for the state.
And Mr. Wilson appears in person in custody with Attorney Clayton Kavanaugh. We have received a copy of the criminal complaint in this matter. We can waive its formal reading. The address in the complaint appears to be correct, and Mr. Wilson is eligible for public defender services.
All right, thank you. The defendant does have an open misdemeanor case assigned to Judge Hilton. We'll get this case assigned to the same judge, and then I'll invite the state's position on bail.
Your Honor, state's requesting $250 cash bail with conditions that the defendant have no contact with Heather W., that he be banned from 9678 County Highway KP in Black Earth, Wisconsin, and that he not possess or consume any alcohol. This is the defendant's third open case. He's violating conditions of bond. His exposure is growing in these cases. And as for failures to appear, he does have a bench warrant issued in both October and November of last year here in Dane County. So that gives the state some concern to failing to appear in court in the future. Coupled with his growing exposure, we would ask for $250 cash bail.
Well, this is confusing. There's two Devin Wilsons with cases pending, it looks like. So I want to make sure we're all on the same page. I think Devin L. Wilson, who is this individual, has two open misdemeanor cases as described by the state, and they are assigned to Judge Hilton. So I think we're on the same page on that, but Attorney Kavanaugh, what's the defense position?
Yes, we would request a signature bond in this case. So what I'm looking at just to kind of be, I guess, upfront is I'm looking at the traffic case 25 CT 536, one of the pending misdemeanors. It's an OWI second. To be frank, there are some missed appearances there where bench warrants have been issued. It looks like they are issued and then served within a matter of just a couple of days when that happens. Additionally, it looks like there have been, at least from what I can tell from the CCAP notes, some issues with notice and transportation. We have some indication that the issue with Miss Court here, I guess the more recent ones, has been due to a lack of transportation. It appears that he's been in contact with his attorney, Mark Leonard, about his missed appearances, in that Attorney Leonard has made filings that I can only assume were at the behest of his client here. I think that's relevant. He's not just kind of blowing off court. There just seems to be some difficulties that he's facing, and he's never gone for very long. I think we have a pretty limited history, no convictions as far as I can tell. And yeah, we have a couple here of misdemeanors, but frankly, 2 disorderly conducts, a damage to property, and a misdemeanor bail jumping with no other prior record. We're talking about exposure. It's just not likely to be significant. I think that a reasonably signature bond could assure that he would appear in court. I don't think we have, inexplainable or really, really serious issues with failures to appear. And there's really no indication from the exposure that there'd be a reason to flee or not show up. So I do think that a signature bond would be appropriate in this case. As for the non-monetary conditions, that seems fine.
Any response from the state?
No, Your Honor.
And the state's request was for $250?
Correct.
And he's on a $500 cash bail already on one of the cases, isn't
I believe on the CT case.
he? Okay. It's a shortcut way to describe the criminal traffic case.
Oh,
Yeah, it's just a set of initials.
yeah. Am I able to speak?
You can, here's the downside. The court reporter here takes down everything that's said, and sometimes things get used against people later on if they talk about the facts of the case. If you want to take a second to talk to Mr. Kavanaugh first, that might make some sense.
I mean, the only thing I was really gonna bring up is that I have court the 16th of July.
Yeah.
For like everything mixed together. And the only thing that I would try to bring up to the state is like, I literally just 2 days ago got a job. I just got into like, it's not gonna matter anymore, but I had the resources for the behavioral health to get in for everything that they wanted me to get into. This domestic dispute, I'm not gonna speak on obviously, but it's completely false, and I just, if I'm gonna be having court July 16th and potentially having to spend some time, and I just get this job, like I had spoke with a family friend on the phone, and they talked to the people. And they're like, if he can get out, like he can still have this job, like they knew it was gonna be a temporary job until I was to go potentially have to sit. I'm not. I don't know.
Oh. Actually, if I may too, I have some thing I think is relevant to add in that. I think I see an indication of at least the contemplation of a deferred prosecution agreement at some point.
I saw that, yeah.
Which I think is a positive in his column. If the DA's office looked at this and said a deferred prosecution would be reasonable, I think that's something positive. Now, I understand probably with a OWI2, we might not be in the same area anymore, but I still think that's relevant to consider.
The OWI2 is before, that's what the deferred prosecution program was like. I don't know, they mixed up.
No, I know that was the first of the charges.
I was supposed to have this jail diversion, and then they were like, we don't do them both at the same time, and I'm still going through that. I just had my what is it called, your assessment or whatever for the deferred prosecution program. It would have been June 17th, it would have been. We had like a 2.5, 3 hour long conversation. Got approved.
have monthly checkups and this whole list of things that I talked to this guy about, which has helped me a lot, trying to get back on track, and like,
Okay, well, I mean,
I just.
I'm not trying to rub this in your face, but obviously things have gone off the rails a little bit
Well,
right
yeah,
now,
no,
but
I mean.
it doesn't mean they can't get back on track.
Since February, definitely, I just think that if it was like a possibility, like, I would have a great amount of. Success to be able to build myself up before the next coming months with everything that's gonna be having to go on, because. Even though that I'm not supposed to go back to that address. I have a very steady friend who I'd be able to stay with, close to work. And the only thing that was being kind of confusing to me is. That address is a 2 apartment address, like this has been one of the main causes of. Whatever this domestic like abuse thing is. I'm trying to get in my grandma's house. And they come downstairs, I'm getting thrown around and I'm in jail for it.
All right.
Like they live upstairs, I live downstairs, I get told to get kicked out and try to grab a sweatshirt and just leave.
And I do want to see if the state has any response to what I think is kind of an argument about the address ban. Because I'm not aware there's an existing ban, there's a request for me to add it today, and I certainly, that still is up in the air. So there, we're part of the.
Well, Your Honor, I mean, we have a case here. A pretty substantial sort of domestic case, and I know it's all alleged at this point, of course. Mr. Wilson is presumed innocent until proven guilty. But the allegations here are that he's at home, lives with an aunt, punching his girlfriend. The aunt intervenes, describes him as being drunk and out of control. He's hiding so he leaves the property, comes back later, hides, and police are called. I think this is a situation where the ban is necessary. It's appropriate to protect the public.
All right, so, well, my understanding is that he has the pending OWI second case. Not the world's most serious offense in terms of criminal justice system penalties. I'm not depreciating the seriousness of OWI and the risks of that, but it's, it's a misdemeanor and a relatively low level misdemeanor. There were problems with making court. Eventually, it was necessary to have a $500 cash bail set. After that was set and he picks up a case where he's alleged to have battered Sydney S, is again released on a signature bond, or is released on a signature bond despite the prior cash bail, with conditions not to engage in threats or acts of violence towards her and not to consume alcohol. And now I have this case that alleges a week and a half or so before the court dates on the other matters that he, factually, it's alleged that he was battering her, that upon the arrival of law enforcement, he flees and hides. And then a number of hours later, there's a whole separate encounter that involving the aunt that ultimately leads to his arrest. I can't imagine setting a cash bail less than what the state has proposed here. And that's not trying to be mean to Mr. Wilson or unmindful of the concerns he raises, because I think I want him to be successful too. I want him to have those tools for success, but it's difficult for me to see how we go to another signature bond at this point. I think he kind of got a gift from heaven getting a signature bond on the open battery case, given that history. And here we are again, I guess. I wish that weren't the case. So I won't set it higher than what the state's proposed, but I can't set it lower than that. I just can't. I'll set cash bail at $250. I'm gonna order the no contact with Heather W. Maybe I missed it. I didn't hear a specific request for any condition involving Sydney S, but maybe I didn't write it down.
No, I didn't ask for any condition for Sydney S.
Okay.
But Your Honor, now that you do bring it up, I do think a no contact with Sydney S would be appropriate under the circumstances.
Because that is a new thing, I should give defense counsel a chance to weigh in on.
I do have a problem with that because she was there, she left, and then the problem only ensued because of mine.
Okay.
Like I said, it's the whole 2 different apartment things. I not gonna say too much, but
Yeah.
it's obviously alleged that I was eluding the police. I didn't even know the police got called. I was just told that I was not allowed inside the house. So I went out into one of the barns, fell asleep. I mean, they didn't find me, so I mean, that's obviously not good for me because I now looks like I'm trying to hide. And then I go back up to the house, offer to get a glass of water and a sweatshirt, and I get the door basically slammed on me, knock again. And here comes this 400-pound man barreling out, punching me in the face and throwing me around like a rag doll.
Okay.
So that's when I went back and fell asleep again and just said.
I'm gonna order it.
But
out.
like, there's nothing to do with Sydney about
Well,
this, the past, yes, but.
yeah, this complaint alleges. It's charged as a disorderly conduct, but it alleges a multiple strike battery to that person also. Given that he's already on a no threats or acts of violence condition, I think that's, the no contact is probably appropriate at this point. I'll reiterate that I'm ordering the no contact with Heather W. I will order the alcohol condition. There's some ambiguity about this 9600 block of County Highway KP thing. I think I'll not set that as a specific condition. But if either of the other two are there, he can't be there because he can't have contact with them. So I'm not sure I'm helping you a lot with that, but at least I'm keeping some doors open, so to speak, depending on how this shakes out. Mr. Wilson, I hope things get better for you. It sounds like you're making some efforts and I appreciate that. It also sounds like maybe you have some chance of getting this all wrapped up here pretty quick, and I sure hope so. I hope it works out.
That's like I've never had, well, I've had a cash bail that I posted, but it was due to. I was already on the way to jail for disorderly conduct, and on the way to jail, I had a warrant. Because I missed court because I was already on the way to jail.
Oh,
So that was probably the $500 one that you were seeing.
okay.
But so like, if there's gonna be no contact against Sydney, that's the only person I've been like, I only have 2 phone numbers here. Sydney and my grandma, and my grandma's technically that address.
Okay, but nothing about what I ordered. If your grandma isn't Heather, there's nothing that prevents you from calling her. I don't think I ordered a no contact with grandma.
And then if I was to get out, the only person that I'd be able to have pick up stuff from me is Sydney.
Okay. Well, I'm not trying to be dismissive of you, Mr. Wilson, but
No,
unfortunately, this is kind of where we are at this point with this
There's just a
history.
lot of confusion with like the address thing, like I said. Because it's weird, it's literally just one big house where there's 2 mailboxes, so there's definitely 2 addresses.
Okay, well, and again, I didn't specifically say you can't be at the address. You just can't be either if they're there, because you can't have contact with them. That's the trouble.
Like even if they're upstairs in their apartment and don't come downstairs at all.
You'll want to avoid anything that might be construed as either contacting or attempting to contact them, because that's what's going to wind up getting you in trouble.
So don't go up there, don't knock on the door, you know.
And it's just with Heather
and Sydney.
So I call my grandma sometimes, Heather will answer the phone, Heather still would answer the phone.
All right, well, I'm not going to outline exactly where that line is, because I don't want us all dancing on it. Yep, but good luck to you.
Right, thanks,
That's everyone's,